Hi, good afternoon. We're just going to give everyone a couple more minutes to join. It's 12 o'clock now, and we'll just give everyone about a minute or two to join in today. We are using the chat for any questions or discussion. So if you're having any issues, please just hop on there and type a message and we will respond as soon as we can. Okay, I think we're gonna get started. So good afternoon and thank you for joining us today on this Association of the Corporate Council webinar around intelligent data management. I wanted to start off with a little bit of housekeeping just at the start of sorry, I have my chat open, so I can't do that. There we go. So before we begin, this session will be recorded and made available to all the attendees after the conference. You can submit questions at any time. We usually do Q&A at the end of this session, but because of the type of attendees that are here today, we'd like you to go ahead and put any of your experiences or questions in the chat, and we can open up the dialogue a little bit more for a little bit more experience sharing between peers. And we can also follow up later via email with any questions that we may not be able to cover today. So the agenda for today's session will include, obviously we'll do some introductions of all the speakers. We're going to speak about the way we organize or don't organize our data, what kind of challenges and risks and costs come along with that. What are the tools and processes of data management, including litigation holds, data destruction and retention policies, and what is the meeting of the minds between legal and IT around litigation preparedness? And finally, then we're going to touch on document review, why good data management will save on overall expenditures for doc review, and then also why it's important to consider the implementation of analytics and advanced machine processes. So in terms of our panel today, my name is Tamara Porter. I'm the Director of Business Development for Legal Services at Ricoh Canada. I've been working with Ricoh for 6 years. After spending a great deal of time in technology around the world, I've been focused exclusively on in-house corporate counsel and working in multiple industries, including energy, airlines, telecommunications, mining, and on all types of legal matters that require data to be involved. And that can range from anything from international arbitrations to litigations, class actions, investigations, audits, and even competition bureau matters. Also today, we are pleased to have Sean Lynch, who is an experienced lawyer and the Director of Client Strategy and Outcomes for Ricoh Canada. Sean has a wide range of litigation, arbitration, competition, US antitrust, and cross-border experience, and both in his role as counsel and in review management. Sean is based out of our Toronto location, and he works with clients to develop strategic analytics and AI-based solutions to address data and legal risk management in our data-heavy environment. We're also very happy to have Jennifer Thompson, head of Osler Works Disputes. Osler's Discovery Management Services, along with many other innovative litigation solutions. Jennifer leads an experienced team of discovery specialists who possess a broad range of legal, technology, and management skills and experience. Based in Calgary, Jennifer and her team collaborate with clients and litigators at the outset of each matter to strategically design customized discovery solutions for clients. I'm going to move on to the first slide, and Sean and Jennifer, I'm going to hope that you're going to join me here. And again, just for everyone who's just joined the call, if you have any questions or any dialogue you'd like to share, please pop that into the chat and we can add to the flow. So Sean, I'll pass it over to you to lead from here.
Sure. So thanks so much, Tamara, and welcome everyone. We're very glad that you could join us today. These slides are pretty minimal. We hope for kind of a lively discussion. So as Tamara said, if anything comes to mind that you want to share, have questions about, please put them into the chat, and we're more than happy to kind of to dig into that. I think we're to an extent fortunate today that there isn't a huge number of attendees, so I think we should take advantage of that and have as much of a collaborative conversation and webinar as we possibly can. So the first slide is about the way we organize, or usually don't organize, our data. And one of the things that certainly I've come across in the last few years has been, just because a corporation is sophisticated, large, international, doesn't necessarily mean that they have a sophisticated data management strategy. Tamara and I are currently working with one of our very large clients that is faced with exactly this. They're very sophisticated in all of their practices and protocols outside of data management, but their data management strategy was limited. And we'll kind of get into that as we go through the slides and use this as an example to explain the challenges that our client has faced, and as a result that we have faced in assisting them with all of the processes that they're trying to overhaul. So as I was saying, sophisticated clients don't necessarily always have sophisticated data management strategies, and that's fine. We're moving into an area of technology and times in, I think, corporate lives where things are getting much more complicated around privacy, around data management, and most importantly, around the transition from server to the cloud, multiple locations to a single location. We're not so much dealing anymore with servers that are located in a vault somewhere that you're storing data on. We're all trying to move, Ricoh included, and actually has moved from a physical data center into an Azure cloud-based situation, like so many of our clients are doing. And there are a lot of challenges associated with that, which again, we'll get into as we get a bit more into the conversation here. But what's key to remember is that the integrity of the data that you're hosting, that you're storing, that you're accessing on a regular basis is incredibly important as you consider the consequences to dealing with that data properly or improperly. And I know that Jen has had some very interesting experiences recently with respect to the server versus cloud mentality and separate entities being, as we say here, separate entities being stored in one place. And I think, Jen, if you want to comment on kind of the sophisticated client, sophisticated data management and experiences that you've had, I think that would be great.
Yeah, I think actually, in my experience, the more sophisticated clients often have the less organized data, and that's just a product of having more data, more departments, having gone through multiple acquisitions in certain cases. And we often see a lot of commingling of data. And that commingling of data can lead to unintended cost consequences down the road. So when companies merge and they merge their data, they have different systems. Often there's an overlap, and it's not easy for us when we get to litigation to identify the relevant pockets of data. And then we have to collect everything, which I'm sure we can all understand then leads to more costs for data processing and hosting, and also more review of irrelevant data. So I think it's just very important for companies at the front end to really consider how they're organizing their data, how any acquisition of another company or different departments coming together, huge file servers that everybody deposits all their information on become particularly difficult. The better organized your data is on the front end, when you get to litigation, the easier it is for us to pinpoint possible areas of relevant documentation and only take that data. So I guess the key in litigation is you want to collect the least amount of data possible while also being able to defend the collection process and the production of all relevant documents.
Yeah, exactly. So Tamara, if you can move to the next slide. And one of the, from our perspective as an e-discovery provider, one of the things that I don't want to say challenged with, but one of the things we often discover when we're speaking with our clients is that there's not a huge conception, or I should say huge, terrible word to use. It's like I'm Donald Trump over here. It's it is usual that we have external counsel, internal counsel, and I think, Jen, you've experienced this as well, that there's a lack of conception around where data can be located, and that it's not just, when it comes to litigation preparedness, it's not just the data that you have on your server or you have in your cloud instance. It's all of the devices that have access to or have accessed in the past all of these servers. And you'll see the list here: file servers, email servers, laptops, work laptops, any mobile devices, iPads, iPods. It doesn't matter. Any device that has had access in the past might have data that is potentially relevant to a matter that's ongoing, and as we'll touch on later, can also become a challenge as you're trying to execute a solid data management policy. So
Yeah,
sorry, Jenny, go ahead.
I think as external counsel and internal counsel, it's our job to advise the business, like, what is relevant data, and it really can be anything. And a lot of departments won't consider certain types of data. So it's our obligation to walk people through things like, any business you've done on a personal device is still considered relevant. Consider your text messages. Some companies now are using Slack and Skype and Teams for business. Those all have their own difficulties because of it's hard to extract these long messages over months and months of time into just the relevant piece. So there's considerations we need to walk through in the collection of that type of data. Databases are often extra tricky as well because they require underlying software to see the data. And therefore we have to talk about the production format and what that's going to look like. And is it going to be separate from data that is less structured? And things like voicemail and calendar appointments can even be relevant depending on the facts. So we need to just walk people through every type of data they may have, which could contain relevant information.
One other thing I would add, sorry, Sean, one other thing I would add to that is just the historical nature when you work with large organizations around redundancies, whether those people left on their own accord or they were let go, especially when we go through economic times. You see more and more turnover, and that turnover implicates into historical type laptops collections that need to be considered as well.
And it does sound, I mean, we sound a bit doom and gloom here, sorry, but it isn't necessarily something that is, it shouldn't say necessarily, it isn't something that is insurmountable. Having a process and procedure that an organization goes through to address all of these issues and locations of data can actually make this process relatively painless, provided that it's set up properly. And I think, to Jen's point earlier, a lot of the reasons why these things kind of get away from us in our industry is that you have multiple different components of an organization that store their data differently, or control their data differently, or give access to different people at different times. And it can be difficult to manage that, but getting an organization to a structured environment where they are utilizing the best tools that are available, and also a robust information governance procedure, really does reduce the workload on the various teams that are involved, and makes it significantly easier in the long run for a team like Jen's to come in and do custodian interviews, find out where data might be, and easily pinpoint it. Tamara, could you move to the next slide, please? So IT versus legal considerations, it's not necessarily like a versus type of situation, but these departments, I think in my experience, and Jen, jump in here whenever you want to, they have different priorities. And certainly having worked with in the discovery business, external counsel, like if I'm working with Jen, and internal counsel if we're working with one of our clients and their IT group, IT tends to be focused on efficiency and budget. They're really concerned about making sure they don't blow their budget, that they're giving ease of access to everyone, they're reducing their storage, and they have a tendency to use lift and shift at the moment. So that's taking information from a solid server that you have, again, in a vault somewhere, to a cloud service like Amazon Web Services, Azure, et cetera, even into Google, for example, into Google Drive, if that's something that a company is using. Lift and shift is great because it significantly reduces the IT spend, because you're not maintaining a server and you're basically just just shoving that off onto Amazon or Google or Microsoft to maintain for you. So it really does reduce cost, but also increases access. Legal, on the other side, is concerned about litigation repair, spoliation, and legal hold. And I think Jen can really speak to those as to why the IT balance of efficiency and swiftness is challenging for a legal department to work within.
Yeah, I think we'll get into the specifics of legal hold and spoliation concerns down the
Yes.
road, but just overall, I think both IT and legal are cost centers to a business and therefore often don't have enough resources for the amount of work they need to get done. I'm sure everyone on this call can appreciate that. But it's very important for IT and legal to connect and for legal to educate IT on litigation and litigation preparedness. And on the front end, to work on document retention policies and what can be retained and what should be, what like organizations should be getting rid of data in a reasonable manner. And that's something that legal and IT need to work on together. But also when a hold comes in, IT has to have prior education about what that means, exactly which policies need to be put in a halt, which departments need to receive it, what they're doing with people that are leaving and their laptops or whatever data they may have, people that are coming, how they treat those people. So it's really just an education process between legal and IT to make sure everybody's on the same page prior to a piece of litigation or a dispute or an investigation coming down the pipeline.
Yeah, for sure. And I think that segues very well into the general tools and processes of data management with the next part of the presentation. And as Jen mentioned, data destruction policy. At the end of the day, you're most concerned about what is defensible and making sure that it's consistently applied. Because what happens a lot of the time in my experience, and I think Jen's as well, is that a company might have a data destruction policy that's totally defensible and works within the information governance framework really well, but they don't apply it consistently. There's a decision at some point, oh, we'll just hold on to that data because we think it might be important. And it ends up being 7 years before anyone realizes it hasn't been deleted. And it causes problems down the road because then it's showing that you don't have a consistently applied data destruction policy, and that it leaves you open essentially as a corporation to risk because you have all this data sitting around that may or may not be relevant to any matter that might come down the pipe. It might be a situation where you have private information or personally identifying information that should have been destroyed but wasn't, and it can just expose the company to risk. What we've been utilizing most recently over the course, I'd say, Tamara, maybe over the course of the last 18 months or so, to quite a good degree, is various data mapping software. And essentially what this allows us to do as an industry is to map an entire server, for example, that a company has possession of, to determine how old are your files, when was the last time they were accessed, who has control over them, and creating from that information, creating a data destruction policy and a broader information governance strategy that allows you to manage the data that you have more easily, as well as reducing quite significantly the amount of junk that you have on your servers that you don't want to move into a cloud instance, for example. And data and information governance can be as simple as naming and foldering conventions that you just put into place. Like if you're trying to do a kind of a baby step type of thing, it can be as simple as that. So for example, at Ricoh, whenever we create a document, we have to name it in a certain way, and it has to include the date in the file name, and the file name in and of itself has to be descriptive of what the document is. You can't just have like document 1, which I'm sure we all have 37 of on our laptops right now in various instances. But just creating a naming convention can significantly reduce the amount of effort you have to go through to find what you're looking for. And then again, as I said, parameters around lift and shift. The concerns with lift and shift, so server to cloud, is that you do get into a concern around preserving the data that identifies what a document is, so the metadata. And if you're inconsistent or quick to pull the trigger on moving a document from a server into the cloud, you can disrupt all of that, which can affect not only your data management and your data destruction policies, but can also affect how a document looks to a system that's trying to identify potentially relevant material for a litigation. And Jen, I think you have had some interesting experience recently around commingling of data and trying to move things from one place to another. I think, if I remember correctly from what we were talking about earlier.
Yeah, so we have had clients in the past where data has been commingled in a way that each entity can't see the other entity's data. So they felt like they had set up a secure system. But what happened was when we came in with litigation, we needed to pull full swaths of documents. And because of the commingling, we had to take all of it, which then meant we needed to review all of it because we had to make sure we didn't produce any of the other entities' data. So when you commingle data that way and you don't have appropriate policies in place, what ends up happening is we can't take advantage of some of the machine learning and analytics we have today, because we actually do have to have eyes on every document for other reasons outside of relevance, to identify privilege of another entity or to identify another entity's documents that we shouldn't be producing. So that again goes to the commingling and thinking all of these structures through in advance so that you don't end up in a situation where you're having to review millions of more documents than you should have. And I think if the courts have encouraged companies to actually have a defensible data destruction policy in place, they appreciate that data is increasing exponentially year over year, and companies shouldn't be forced to save decades of data, and that it is reasonable at some point in time in your business to destroy data that is quite old. So as long as that process is defensible and consistently applied, the courts will stand behind those policies if they're reasonable. And this type of organization in a company doesn't only help with litigation preparedness, but it will assist everybody with their day-to-day business, finding items. I'm sure we've all spent hours looking for an email we know is somewhere, or a document we know we've seen in the past. So when we do this front end work, we actually end up being way more efficient in our day-to-day business, and that contributes to the overall happiness of everybody in the company.
Exactly. And I think the next slide is, I think this is a good segue into the destruction of documents. So we'll get into the legal hold component in the next slide, actually, or the next two slides. But I think building on what Jennifer said, so data destruction and retention policy should always be reviewed, and there should be procedures that you publish to the entire company so everyone is aware of what the data destruction policies are. So that no one is caught off guard by documents being removed or destroyed in accordance with the company's policy. And procedures around transferring any information, et cetera, to another individual, to individuals outside of your organization, should also be understood. And I'm sure there are many of us on the call that have, if information comes in from an external party, you get the subject line external in your email. We at Ricoh have a retention policy timer that attaches to all of the documents that we create in Outlook, for example. So we know if we're going back to find that elusive email from 17 months ago, the system will tell us, well, in 3 weeks, this is going to be automatically deleted. So again, as the policy is designed, as Jen's saying, to minimize the amount of data that you do have to have stored on a server, that you do need to have in your possession. And for various reasons, the courts have recognized, as Jen said, that it's not necessary to maintain all of this information forever and ever and ever, for a number of reasons. One, it's almost impossible to do because data growing so quickly, it gets very, very, very expensive, disproportionately expensive to maintain all of this data, and we don't want to be doing it. And two, again, it gets into situations of what is the data actually providing us? And is the information that's contained within it problematic in the sense that it contains PII, or in the sense that it's containing confidential information, or information that wasn't confidential before but now is? And you want to make sure that you have control over that, just to make it easier for you to navigate all of the data that your company is undoubtedly controlling. So I think the The next slide goes into legal hold and preservation obligations. And I will 100% turn this over to Jen Thompson, who is much more knowledgeable about this than I am. So Jen, please take it away.
So legal hold should be implemented as soon as litigation is even contemplated. So the example I always use is if your company's boat has spilled oil into the ocean, you probably should implement a litigation hold. There's obviously no litigation at that current time or even a threat of litigation, but it should be reasonably contemplated at that moment. It is the company's obligation to issue that. Obviously, we as external counsel advise on what the hold should look like, who should receive it, and all of those considerations need to be thought through. As I said before, it's very important that IT understands the importance of a litigation hold as well. And that really just goes down to an appreciation of spoliation issues and the consequences of inadvertent data destruction. So if a court has found that data has been destroyed and it unreasonably so if there was a lack of consideration around the fact that there should be a litigation hold, there are consequences that they can implement. So some pre-trial sanctions are they can revoke or suspend the party's right to initiate or even continue examination for discovery. They can dismiss the action or strike out a statement of defense, depending on how bad the spoliation is. There are other orders that can be made, cost orders, prohibition from using certain evidence at trial, loss of the right to reply on an expert report, or even findings of contempt. If the spoliation is discovered at trial, there can be an adverse inference made about the company's case. Again, cost consequences can follow and damages awarded can be affected by spoliation issues. So it can be a multi-million-dollar issue if data is being destroyed in an unreasonable manner. So that's why it's very important that a litigation hold is put out to the company in an expedited manner, and IT understands all of the consequences of that hold, including stopping any data destruction that might be automatic. Like lots of companies have automatic deletion of emails after a month or 30 or 60 days. That has to be stopped only for people that may have relevant data. And for turnover, so new people coming to the company, people taking over existing roles, lateral hires, all of those people, we always have to be keeping in mind, oh, they should be receiving that litigation hold the second they start in that role, because often litigation holds will have ongoing preservation obligations. So it's not just the data you had at any point in time. Also, the data in your business as you move forward might be subject to a litigation hold. So it's important to understand that these memos need to be refreshed. We often ask that people sign an acknowledgement on a yearly basis, just to ensure that we know that they remember they're under a litigation hold. So all of these are considerations that you should speak through with your external counsel, and we have checklists to make sure all of this has been done. We have model litigation holds to help with all of this. It's a very complicated part of the discovery process for sure.
Definitely. And I think the overall goal of the preservation and litigation hold process merges very well with the idea of information governance, and that what you're trying to do is preserve documentation that is the most salient to your business, that does not contain information that you don't need to be holding on to, like PII, et cetera, financial information that may or may not be relevant to the business. But being able to map and identify all of this so that when it does come time to instigate a legal hold, you can run custodian interviews, you can understand very quickly where your relevant material might be sitting, rather than in the experiences, like, for example, that Tamara and I have had recently, where the client had built up many, many different servers in many different locations and wasn't really sure where anything might have been. And while that might not sound as a huge problem because, well, it's just a few different servers, the issue is over time, data grows so much that you end up looking at something like 100 terabytes worth of data and millions upon millions of documents. And if you're trying to find those documents that are responsive to a specific issue in a litigation, combing through 100 terabytes can be very, very difficult, rather than combing through maybe 5 to 10 if a proper information governance process had been implemented in the first place. It makes it much more protective over the organization. It significantly reduces legal risk, and a result of that, financial risk and reputational risk, because you're not faced with a consequence of, as Jen was outlining, what could come from the court if you don't have the proper documentation available, if you've destroyed it, or you can't find it and you should have it. All of these things feed into the principle that solid information governance, including data destruction and legal hold processes, make it significantly easier for a corporation to gather and maintain good data and not have exposure to essentially what we would consider bad data that is irrelevant, that is old, that's trivial, that you don't really care about. And that all feeds into the next part of the presentation, which is around what are the consequences of poor data management. And the example we're using for this particular webinar is document review, because document review is the most cost consequential and cost intensive portion of any litigation. Even if you have something, you've got 50 lawyers involved on something and it's cross-border and it's crazy town, and you think that the legal costs are going to be the biggest component, it's not. It's going to be the cost it takes you to review all of the documentation that is gathered for the purposes of responding to a litigation claim or for instigating one in the first place. And to Jen's point earlier, when you're getting into a document review, you want to make sure that the data you're gathering is as good as it can be to do your best to limit costs associated with doing that. Generally speaking, there are two methods that we use right now for conducting document review. Traditional document review, which is a linear eyes-on review, which as Jen mentioned earlier, if you have a bad set of data, this is probably going to be the way you have to go because you're limited as to what other tools you can use, versus a technology-driven review with artificial intelligence or machine learning. When it comes to good and bad data is kind of what we've been talking about here with poor information governance policies. You've lifted and shifted too soon without preserving your metadata, so it's corrupted. You have inconsistent storage methods, so you don't really know where relevant documents might be living. You might have 100, 200, 300 duplicates of a document or near duplicates of a document that are all kind of the same. Some of them are 10 years old, some of them are 10 weeks old, and you don't know why you have so many of them. And then you have multitudinous locations because you've stored multiple copies of the same document in different places that are controlled by different people that have been editing them over different periods of time. So that would be kind of an example of bad data. The reason we want good data, one, there tends to be significantly less of it, which means that from a processing and hosting perspective and costs associated with conducting e-discovery processes, your costs are going to be way, way lower. Number two, it gives you quite a jump on strategy, because rather than spending a significant amount of time with external counsel on lots of phone calls with IT in trying to figure out where all this data might be, your starting point is, oh, I know where all of this is because my information governance policy that I'm 90% confident everyone in my organization is following. There's always going to be some outliers, to be honest, but I'm 90% sure that this is where everything is going to be, which means that your internal cost as a legal department is significantly reduced. You don't need as many resources to manage a large-scale litigation. Two, it means you don't need as much work from your external providers, whether it's a third-party provider like Ricoh is, or external counsel like Jen would be running. You don't need as much of that work because your data is in good shape. And finally, and probably most importantly, if your data is well organized and your metadata is maintained, when you take all of that information over and you utilize a technology-driven review, you end up with significantly better results. And Tamara, if you can move to the next slide, just so we can And I would just like everyone to know this is Jen Thompson's most excellent EDRM slide. That is significantly better than the one that the EDRM puts out. So just kind of like talking through or touching on each of the things we've been talking about today. So we talked about information governance, the custodian interviews, identification of where that relevant document might be, the preservation or legal hold of that information, the collection of that data. So that would be, for example, Ricoh going in and collecting all of that information off of servers and preserving it, ingesting it into a review tool, utilizing analytics, reviewing it, and then producing it to the other side for the purposes of moving forward in a litigation or for discoveries. In addition to that, there's the contemplation here, and something that Jen has added to this slide, which I think is incredibly useful, is the archiving component of things. So if you're going from good data to good data in an archive, it also means that your costs are again significantly reduced because you're not dealing with an initial set of data that is so large that you're trying to preserve all of that for the purposes of maintaining the audit trail between where it came from and where it's gone to. And we're facing that with the same client, similar situation, where massive amount of data, and we can't get anything off of the servers to lift it into the cloud because we don't want to be in a situation where anything can be challenged around the preservation of the metadata and the preservation of the original location of that information. So good data begets good data and just reduces your cost and cost consequences and timelines across the entire EDRM and for the entire course of the litigation. So aiming for good data is, well, important. And I think Tamara, if you can move to the next slide, please.
Just quickly before we move on.
Oh, sorry, Jen.
No, I know
power through that.
We've driven this point home, but I want to focus on it a lot. It's the cost consequences that we're really talking about here. So at each of these stages, the cost consequences of having good data versus bad data is extremely different. So information governance, right away, you're going to have only good data if you have good destruction policies in place, which means hundreds of thousands of documents aren't even going to exist for discovery. Identification, you'll have less to identify. It'll be easier to identify. The time spent to identify will be less. Same with the collection. The interviews will go smoother. Will take less time out of your business unit's days where they're trying, like anytime they're spending with us is time away from what they should be doing for the business. So if all of this is clean and fast, you're going to save money. Ingestion there's a per gigabyte fee with most vendors for processing. So just ingesting in large amount of data is thousands and thousands of dollars. And then if we can't run analytics on it because it's bad data, that means we have to review all this excess data. If we can run analytics, on good data, we can deduplicate 30% of the set. We can email thread another 30% of the set. So some of the things you can do with good data, get these review sets down to such a significantly smaller size that the costs are really, really morphed by good data versus bad data. And
I think to put that into context, when Jen's talking about like significantly reducing, we're talking like orders of magnitude. Like you will go from a data set that might be, as I said earlier, like 100 terabytes, and you might, through all of these processes, be able to reduce that data set down to 2% of what it was to start with. So the good data, going from 100 gigabytes or 100 terabytes, let's say, to 2, or 1,000 gigabytes to 200, or sorry, to 20. It's a significant reduction overall. And if you can do that at the start, rather than collecting massive volumes of data just to ingest it so you can carve out all the junk, you're going to save tens of thousands, if you're a large corporation, hundreds of thousands, maybe millions of dollars worth of cost. So investing in an information governance strategy at the start, it keeps yielding benefits down the road. Because bear in mind, you're likely going to be subject to more than one litigation over the course of corporation's existence. And if you have a good IG policy, all of that work just yields huge results on every single litigation that you have going forward.
Yeah, and I would just add to that, Sean, having lived through a few massive projects, where
We,
the
Tamara,
collection,
have we done a lot of large projects
yeah,
together that were crazy?
where the collections were very expansive and fulsome, which is great from a defensibility perspective. But we continue to educate the market on the importance of information governance before the event happens, before the legal matter approaches. Let's do this way in advance so that organizations are in much better shape when it does happen, because it will. It always happens. And we've figured out ways to get through it when there have been massive collections, but it makes it that much more time consuming, difficult, and costly, as you've all said. So there are so many tools in the market and lots of providers that can, provide services along the lines of giving good governance to an organization and getting a hold of the data. I find that any organization that has been around for 10 to 20 years has got this issue. And so it is an investment that is worth, pushing up the chain of command into the top levels, because it will reap benefits over the long term. Sure.
For sure. And I think Tamara, if you can move to the next slide, like one other thing, building on what Jen has said about deduplication and email threading, these are all tools that we have at our disposal that shouldn't be unusual or alien to anyone on the call, because you use them every day. And if you have email in Outlook or Gmail, you've seen email threading with the taking multitudinous emails and putting it into one string that you can read really quickly. Deduplication is what it is, in that you're just taking all the duplicates of a document, identifying them, and only putting one of those duplicates, or the principal duplicate, into your review queue. So you might have 100 of the same document, but you really only need to look at one because they are the same thing. Using all of these tools has the same effect as a good information governance policy does, in that it reduces your costs significantly and it preserves the good data that you have. What we want to be able to do is collect, process, and analyze faster and more easily with good data than we can with bad. It's faster, it's cheaper, and then we can use tools like machine learning and AI. We use the tools essentially because it's faster and more accurate. It allows better QC options and it reduces costs. And certainly in my experience, having run document review teams and large kind of internal legal teams that are reviewing documents, and I think Jen would say the same thing, that the machine learning tools and the AI tools, at the end of the day, they're really reducing costs and they're increasing accuracy, and they allow for better QC. Because no matter how good you think you are as a person reviewing documents, you're never going to be as good as an objective machine doing it. And I think Jen would agree, like that's what our experience has been with this. Like the people make mistakes. Yeah. Machines make mistakes too, because they're being trained by people, but the tool allows us to see that much more quickly than we would if we were just manually going through these documents.
Yeah, it's the combination of the AI and machine learning with the eyes-on lawyer that leads to the most efficient review, the highest quality review, the most defensible review. Like we'd often, I would not do a linear review anymore unless there was some extraneous reason to do it. It means that you have to have a lawyer look at every single document in your data set, which it takes on average, like a lawyer an hour to review 50 documents. So if you have 100,000 documents, you can imagine how many lawyer hours that amounts to. So with the machine learning and the active learning, what's happening is the analytics are pushing what the machine thinks are the more relevant documents to the front of the queue. So you're seeing all the relevant documents right at the beginning of the review. You get through it until at one point you can call the review based on a statistical margin of error. And we see review sets where we haven't had to look at 50% of the documents or 60% of the documents, depending on what the relevance rate is in that data set. So the amount that the machine learning combined with a lawyer reviewing can reduce data sets is astronomical. And we, like I said, we use it on almost every file we possibly can use it on now, because it is so helpful in reducing these data sets. And I mean, it's been developed because data sets are growing every year and are just unmanageable on a document by document review.
Yeah, absolutely. And Ricoh was the pioneering beta tester for active learning with relativity in Canada. And even from its infancy, active learning has demonstrated, and similar machine learning tools have demonstrated the significant time and cost savings for document review, as well as the increased accuracy. Courts have taken notice of this. It speaks very well to proportionality arguments that you should be using this because it greatly reduces the time and the cost associated with doing a review and increases the accuracy. Like it really is a combination of all the best aspects of what we can do now as an industry, from legal expertise in assessing relevance to the third-party providers and our technology specialists who are able to utilize these tools to their best degree. Really does provide a significant benefit overall to our clients, and I think to the pursuit of justice as well, because it does significantly reduce the cost of pursuing a certain action or defend against one in ways that we haven't seen before. And as data keeps growing, these tools are going to become more and more important, just like information governance now is becoming more and more important by the day, because you don't want to be collecting a bunch of junk that you don't need to look at and paying for the privilege of looking at junk. Nobody wants to do that, and nobody wants to pay for that.
Sean, we have a question in the Q&A.
Oh, super.
What have you generally seen in terms of the retention period in destruction policies? For example, 10 years across the board to align with ultimate limitation periods, perhaps something less. It seems to be a balance between, yes, discoverability costs as a defendant, but also ensuring a company has the documents for long enough that if they commence litigation as a plaintiff, they have the business records and evidence they need.
Sure.
So,
Jen, you go.
Retention period in destruction policies.
Go ahead, Jen.
Okay. So we actually we review document retention policies and document retention charts all the time. It's a tricky question to answer in a vacuum because it's very dependent on the company, your business, what you do, likelihood of litigation, likelihood of needing these documents. In a nutshell, it comes down to a reasonableness standard, which is what is the likelihood that you will need these documents down the road in litigation and they won't be available? And what's the likelihood that you would need how many years back? Like, is 20 years of data ever really going to be relevant to a piece of litigation for your business? So we need to consider a plethora of things, including where your company is incorporated, what provinces do you operate in, where are your corporate documents actually physically maintained versus are they in the cloud? All of those pieces become relevant to what is reasonable in terms of retention and destruction policies. So it really is hard to have a bright line rule. Yes, we do often so there are categories that fall into different pieces of legislation. So tax documentation falls under tax legislation, and each piece has their own limitations in that way. And then we have the ultimate limitation period, which differs over provinces. So that's also why we need to know what province you're operating in, et cetera. So long story short is we need to look at the particularities of your company, but there are some kind of bright line rules that we can go over with you. Mm-hmm. Sean, did you? I don't want to.
No, I don't think I could add absolutely nothing to that, Jen. No, that's awesome.
Okay, great. Should we move on? Are we?
Yeah, I think the next slide is Q&A. Yeah.
Yeah. So we have a few other questions. Let me read them off to you, Sean.
Sure.
And Jennifer, what would you recommend as a way to address the disconnect between legal and IT?
Oh, this is a Jen question.
So I actually offer a presentation for IT about these exact issues. I've presented to many clients about preservation obligations, what a litigation hold looks like, do's and don'ts in terms of presentation, consequences of the failure to preserve. I'm happy to come and talk to anybody's IT team about these issues. I think it's important to get ahead of the game, and I do these presentations because it makes my job easier at the end of the day. So I'm happy to come and talk to any IT teams.
Yeah, absolutely.
Yeah.
Okay, another one, is it really okay to just delete data?
Yes.
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 Please do.
Yeah. And I mean, in accordance with the information governance and retention policies that you put in place as an organization, and as long as they've been assessed and they are defensible, yes, absolutely. You should have no qualms about deleting data. And I'd say from my experience, being a lawyer, being a litigator, for the longest period of time, I was terrified of the idea of deleting information. It just seems like, well, why would I ever want to delete it? Mostly because, and the reason why we end up in these situations of having so much data is because storage was really cheap. And the mentality was, well, why would we get rid of it? It's super easy to just keep it over here. We'll just hold on to it forever. That way we're not scared that we won't have it. And that might have been all well and good 5 or 7 years ago. And I don't think that argument really holds anymore. Because once you have a policy that you're implementing that is defensible, that works for your business, as Jen was saying earlier, you should be implementing that policy with no concerns whatsoever. Just be consistent, be vicious when it comes to deleting data that you don't need, because at the end of the day, it's just going to make everyone's lives significantly easier down the road, I would say. I mean, Jen might have more of a legally caveat to that. So I'm not sure.
Yeah, I think my only caveat is emphasis on the defensible and consistent, because if it's unreasonable, if you're deleting emails after a week, then you're going to have it's going to be hard to stand up in court and argue that that was a defensible approach to your business. But if it's defensible, the courts aren't expecting you to keep boxes in Iron Mountain for 100 years. So it's a reasonableness standard, and consistency is key. So if you have a rule, you have to make sure IT is applying it, because if they're applying it here and not there, then you don't have a defensible mechanism, even if it would have been defensible if it had been applied consistently. So you just want to ensure that the process and the procedures are ironclad, and that someone has reviewed it to say, yes, we think this is defensible for your business.
Okay, great. One more, or actually two more. First is, how do you identify who is subject to a legal hold or preservation order?
For that one, Jen.
So again, external counsel, we can assist you with that. So preservation obligations, we tend to say, should be broader than your production obligations. So we want to cast a bigger net on preservation and maybe collection than what we're actually going to produce. So your production obligation is any document relevant to the issues in the litigation. When we talk to our clients about preservation, we ask them to preserve anything that might reasonably be relevant. So it's a bit broader net, and we will sit down with usually legal and go through different custodians, different departments that might have to have a broad, like you might need a broad hold over all of accounting or all of a certain business operation, or it might just be this one person's email that's relevant. So we're just gonna put a hold on his email, take his PST, which is a container file for emails, and review that information. One thing that clients don't often consider is that you can have preservation obligations over third parties, affiliated entities, parent companies, subsidiaries. So it's a power and control test. So if you have possession, power, or control over the document, you have an obligation to preserve it. So if a third party has your documentation and you have a right to request it and receive it, you are then obligated to preserve that documentation with the third party to the extent that it may reasonably be relevant. So that's another thing that a lot of people don't consider when they're going over these preservation obligations.
Okay, great. Sean, did you want to add anything to that?
No, I don't think so. I think that's exactly what should be considered. I mean, the only other thing that I'd throw in there is that when it comes to identifying who might be subject to this, it's just a matter of running custodian interviews, which is certainly something that we at Ricoh have assisted with in the past. I'm sure Jen's team does that like every single day, figuring out who might be in control of that information. It gets a little bit complicated when it comes to really large scale organizations, because again, you might have one or two people that kind of pop into a project for a few weeks and then leave it right afterwards. Happens a lot in large scale construction files, we found. And it just means that you need to, one, do the best custodian interviews that you possibly can based on the information that you have, and to be prepared that as you start working through your documents and as you start working through your collections, you might come across additional individuals that need to be collected. So don't be surprised by that. Don't be worried about it. You know, it happens. You're never going to know from the outset every single little bit and piece around the litigation and who might be holding on to relevant documents. With a good information governance policy, you'll be certainly assisted in that process just by the nature of the way the information is organized. But it might come up that you have to collect another individual or two as you're going through it. And there's nothing wrong with that. So don't be worried. And further to that point, the technology that we employ in all these large scale reviews, or even not even large scale, even any review really, to Jennifer's point earlier around using deduplication and email threading, it will take into account adding additional data into the stream. So you don't have to be worried that, oh, if I collect someone afterwards, it's going to mess up the entire process. It isn't going to. It really won't. And there are lots of controls we have in place in the industry to ensure that when that additional data comes in, it is dealt with properly in the grander workflow. So don't worry about that.
One last tip on this too is at the end of every custodian interview, we ask the custodian if they know of anyone else who might have relevant data. And that has led us to people that have huge swaths of relevant data in many instances.
Yeah, good point. Okay, so we just have one last question, and I know we're getting to the end of the hour, so thank you everyone for hanging in there. But so spoken a lot about good data, quote, and as data that is well organized. Are there other parameters that could indicate good data versus bad data? Maybe Sean, you can start.
Yeah. I would say that organization is one component of it. I would say that ensuring that you're, again, from a general policy perspective, that you're including in what's the best way to say this? That you're making sure that your teams and the individuals that are working on this data are following certain policies around naming conventions and identity of the documents in certain locations. So it's about auditing and enforcing your information governance policy. So yes, it is a way of maintaining good data, because it's an active process. Information governance isn't going to be like, well, here's the policy, everyone, please go follow it. It isn't going to work that way. You're going to need to do other things to ensure that the good data you started with is preserved by all the individuals in your organization. And I think as well that the other thing that you want to make sure you're controlling for is what we call ROT. And ROT stands for redundant, obsolete, or trivial data. So redundant being, you have thousands of duplicates of the same Excel financial report, you really only need one. Obsolete would be that data that's really old that you don't need anymore. And trivial would be, you have, a birthday card in your email from someone else in the office. Like you don't need to keep these things, right? Good information policies will address ROT in advance, but it's certainly possible that as you go through the process, you'll identify additional things that need to be removed. So it's important, as Jen was saying earlier, to constantly review and update your information governance, your data destruction and retention policies, because it will make a difference in the long run. If you're an organization that thinks you have a lot of rot, which, let's be honest, lots of them do, it's worthwhile reaching out to a third-party provider, to your IT department, encouraging your IT department to work with a third-party provider to identify all the material you might have on your servers or in your cloud instance that you just don't need, that you don't need to be paying for, that you don't need to expose your corporation to the risk of possessing. Because all of these processes will allow us to get as a, to the ideal state of having nothing but good data in our possession.
Yep, for sure. And rot, I mean, on average, 50% of data, unstructured data that's carried by large organizations is considered to be rot.
Yeah.
So that's significant.
Yeah. Think about the cost there.
Perspective. Yeah, for sure. Okay, great. Well, I don't think we have any other questions in the Q&A, and we're right at the end of the hour here. So I'm not sure, Heather, if you want to just jump back on, but thank you so much to the ACC. Thank you, Jennifer, and thank you, Sean, for all your insightful, oh, wait, hang on, we got one more. Oh, no, thanks for a great discussion.
You're welcome.
So we're all good.
Welcome. Thank you for having us.
Thank you so much. And everybody enjoy your Wednesday.
Thank you on behalf of ACC Alberta for the three of you for coming today. That was fantastic.
Okay, great. Everybody have a great week. Thanks so much.
Bye, everyone.
Bye.